Hello everyone, my name is Daman. Today I'm going to cover understanding GS, which is Genuine Student, used to be GTE, Genuine Temporary Entrant, requirements for student visas, SC 500. So I'll be providing all the information which will be helping you in preparing a strong case. I started my career as an education consultant in 2011. And then I studied migration law. I got admitted as a lawyer in 2023 in Queensland, and now I'm working at Kris Ahn Lawyers, handling all kind of visas, especially student visas, employer sponsored visas, and range of other migration matters. So the objective of the session is understanding the GS, which is Genuine Student, previously used to be GTE requirement, and why it matters, and then learn how Ministerial Direction 106, previously 108, guides assessments, and identify key factors that affect GS and GT outcomes. Tips to build a strong case. Let's start with this. What is GT or GS? So GT used to stand for Genuine Temporary Entrant, and GS is Genuine Student. So Genuine Student is equal to genuine applicant for entry and stay as a student. So the student visa program is provided for people to come into Australia to study and stay here temporarily and then return back to their home country. So that's mainly they want to get out of the students. So this requirement continues to form part of assessment of whether an applicant is genuine student for the application made. Remember this point that prior to 23rd of March 2024, it used to be called as GTE, and all the applications were assessed under Ministerial Direction 108. Post 23rd March 2024, it started as a Ministerial Direction 106. Since then, GT has been replaced by GS, Genuine Student Requirement. These are required by Migration Regulations Schedule 2, Clause 500-212, and applies to all Subclass 500 student visa applications. Why the GTE GS criteria? Why I am referring to GTE with GS is, the reason is that a lot of cases which are still with ART, they will be assessed under GT criteria, MD 108. So that's I'm referring both of them in this slide. So it prevents misuse of the visa for migration or permanent residence by people with no genuine study intention. Ensures Australia attracts genuine students who want to contribute to education, not people looking to stay here for other reasons. So what they want is, like, if someone is coming over here on a student visa and they're keep extending their student visas, or they're trying to apply other visas, they don't want this in. They want to assess, like, are you coming to Australia to study here, or is your pure intention to study and go back to your home country? Let's talk about Ministerial Direction 106, how GS is assessed. Let's talk about what is Direction 106. It's assessing the genuine student criterion for student visa and student guardian visa applications, which is SC 500 and SC 590. This direction provides mandatory guidance to decision makers on what factors require consideration when assessing whether the applicant genuinely intends to stay in Australia temporarily. So they are legally binding under Section 499 of the Migration Act 1958. These are the written directions about performance or exercise powers or functions under the Act or regs. The minister cannot use this power to direct outcome of a specific case, but can guide how decisions in general should be approached. It's not a checklist. It requires a reasonable, balanced judgment. Factors which are considered under Direction 106, the first one is the applicant's circumstances in their home country. It includes other things like economic and political conditions, financial and political unrest in their country. Like, let's say example, current scenario, there was a conflict between India and Pakistan. So if anyone trying to apply during this situation student visa to Australia, the case officer will take this in note that is this student coming here generally and will be going back to their country, or are they just applying for the visa just to come to Australia and stay here because there is a political unrest or there is some conflicts going between two countries. The personal ties, like if you have a family over there in India, siblings, parents, if you have a job prospects in India, if you have done your research, what you will be doing after completing your studies, if your family has a property, you got a property. So all these conditions are covered in there. Study options, if similar courses are available in the home country or not. So why you are choosing Australia? Why you want to come to Australia? Are these courses available in your home country or not? If yes, then what's the difference between the study modules in India and Australia? So people need to explain it properly so that case officer can understand the basic differences. Another factor is military service. Any mandatory military service, like if I'm coming from a country where I have to oblige by a military service, then am I trying to avoiding that thing and coming to Australia, and then if I don't have to do anything over there? So a lot of things to be mostly many other countries which are a part of where the military commitment is mandatory. So case officer have to see that if they have a military commitment, have they completed it or it's still pending. So maybe some people will think, okay, I'm going to Australia and I'm not returning back to complete my obliged by my military commitments. Other factors are the potential circumstances in Australia. So ties to Australia is the first one. It reviews like any existing ties to Australia due to which they may stay beyond their visa period. That can be family, that can be a relationship, it can be a de facto or marriage. So they will look into these factors. Use of student visa. Student visa is not being used to circumvent the intentions of the migration program or maintain PR. So if I'm intending to complete the course and my intention are to get the PR in Australia, then case officer needs to see in my statement of purpose that what is my primary goal. So basically, if you're showing your primary goal is to study in Australia and go back to your home country and work in a particular field, or you're going to open your business, start your own business, then it will be great help. Knowledge of Australian life. Consider the applicant's understanding of living in Australia. So when you apply for the student visa, there are various factors. Why Australia? Why this city? Why this university? What are the costs? Living costs and everything will be considered. So if you provide those information in your statement of purpose, it will be helpful. Relationship of concern, whether the primary or secondary applicants entered into a relationship for a successful student outcome. So there can be other examples for this. If I came on a student visa and then I entered in a relationship with someone to gain a student visa, that will be considered. The other factors are value of course to primary applicant's future, which is once an applicant completes the course, what they're going to do, which occupation they will be working, what salary they will be getting, and which businesses or organization they will be working in. So that will be required to provide the full detailed information with a full research by the applicant, so that the case officer can determine what is your primary goal. And the applicant's immigration history. It includes immigration history and the travel history. If you have traveled anywhere in the world, it will be seen that have you complied with the visa conditions or not. And also it will be, if you were in Australia, have you complied with your visa conditions or not? So all these things will be considered. The intention of a parent, legal guardian or spouse of the applicant. If minor, what happens is like if minor is coming to study in Australia, they will be looking at what is the primary purpose, what is the primary goal of the parents or siblings or spouse of the applicant if they are studying in Australia. So that will be looked into. What are their main purpose? Any other relevant matters that may influence the decision regarding the applicant's intention to stay temporarily in Australia, like multiple course loads, satisfied course requirements, participated in assessment levels, commenced and completed course, progress, study gaps, changing courses. So it all depends negative and positive factors. If you have been studying different courses back to back, are you completing all those courses and are they relevant to each other? Or if you are changing the courses, what's the main factor why you want to change from this course to other course or other stream? So that will be taken into consideration as well. There is a legal principle which was held in Miak vs. Khadgi, 2010. So this was judgment provided by the court, federal court. So it says that weight to be given to any one factor or group of factors is a matter for the decision maker and will vary from case to case. And the extent to which the decision maker is required to engage with each factor will often depend on the matters put forward by the applicant. So when you submit the visa application, you will be providing all the information regarding as per Direction 106. And if you are meeting all the criteria or if you're not meeting all the criteria, this will be taken into account. So in this case, Khadgi case, he was a Nepalese guy. He applied for the protection claims and his visa was refused. And then in tribunal, AAT also refused his appeal. And he went to the federal court where his judgment came out as RAT had failed to engage with the substance of Khadgi's claims and evidence. So it says that the tribunal assessment was overly narrow and did not consider key aspects of the persecution claims. because he claimed that if he go back to Nepal due to his political views, he might get persecuted. So that's why he lost a protection visa. And finally, the case reaffirmed the requirements that the decision makers must engage meaningfully with the core aspects of an applicant's case. If it's not done, then it can amount to a jurisdictional error. So we have done a research on recent reasons for refusal. Unfortunately, all the refusals and all the ART recent cases, they are dependent upon GT because they were lodged before 23rd of March 2023. So they are under Ministerial Direction 108. So we have prepared an extensive compilation of recent ART decisions to remit or affirm student visa refusals, identifies instances wherein GT criterion was satisfied, and also used findings to tailor a client's case to address the consideration in our submissions. On next page, you will see what kind of analysis we do. So there are two cases. One is remit for reconsideration, which meets the criteria, and other one is doesn't meet the criteria and affirmed. So Shah Thakuri case, whether the applicant is genuine applicant for entry and stay as a student. So being a pattern consistent study, what was found, he was being a pattern consistent study since January 2021 and academic progress during this period. So Shah Thakuri was performing well, progressing in the course. So that's why academic progress is more important. This is why we always ask and we always emphasize in our submissions that transcript and attendance is a sign of academic progress, and that he was a genuine student and had to complete his studies. So this is how we use our submissions, and we put all the information there. The other case is that lack of academic progress, diploma, advanced diploma were not completed, insufficient funds for study. So the tuition fees is not going on time, you're not performing, you're not submitting your assignments, you're not completing your course, living in between, that will lead to the refusal because department will always check your progress. Below is a link to the table here, which is the AAT chart. So we will be updating it now and then. You can see the recent cases which we researched and found which cases meet the criteria and which cases doesn't meet the criteria. And there's a summary for reasons for 500 visas, AAT documents. So it shows the list of factors, negative factors and positive factors, which will help people to determine what to use in their student visa applications and what not to use. The reasons for refusals, let's say negative factors. So weak ties to home country. Example, no property, there's no job prospects, you don't have any experience. It can be like some people, they are recent graduates or recent school pass outs, so they will not have any experience. But family property, what they will be doing once they go back to their home country. So this will be considered. Sudden change of career without a career plan. I will give an example of one of our client who was from Korea and he came to study here in Australia, commercial cookery. So he studied chemical engineering before and he took admission in cookery. So his visa was refused under Ministerial Direction 108. And we won this case because we provided all the relevant documents which were required. So I will be covering those documents in the next slides. If the students enroll in low quality or cheap course enrollments, that's also a negative factor. So you should be choosing the right course in the right college. So there are many colleges which don't comply with the ESQA code of conduct. So you need to check if the college is on a proper roadmap or not. Regression of study. If the visa applicant has chosen a course that appears to be a step backwards in terms of academic level or career progression compared to previous studies or qualifications, that will be a negative factor as well. So for example, if someone has done masters in IT and they are going down to the Cert 4 in commercial cookery or you can say automobile, if they can't explain why, that will be the issue. That will be considered as a negative factor as well. Long stay in Australia on temporary visas without study is another reason for refusal. Applying for student visa right after visitor visa without adequate time or evidence of planning to undertake course. So now the government has stopped doing this and they put the bar that visitors can't apply for the student visa. So this factor in current scenario is not working. Previously, a lot of applications were refused due to this adverse immigration history. When if person is not complying with their immigration visa conditions that will lead to the adverse history. If there is anything, any visa refusal, and they are applying for other visas back to back, that can lead to the negative factor as well. Poor evidence of financial capacity. Financial capacity is the requirement when you're studying in Australia, when you apply to study in Australia. If you are not able to show that you can support yourself for the duration of your course, including your tuition fees and the living funds, and if you have your family coming with you, then you need to show funds for your partner and your children, including their education. So this whole needs to be shown. If you can't prove the enough funds which needs to be required for the study in Australia, you might receive a refusal. So here are some satisfying GS requirements, positive factors which we can say. So clear plan, clearly linked to the course. So if you want to study something, you should have a vision, you should have a goal, you should set aim that I'm going to study this thing and then I'm gonna do certain job or business after this course. So that should be clear. Proper explanation of career change. As told you before, that if you are changing careers, then the appropriate explanation is required why you want to change from mechanical engineer to cook, anything. Clear intention to return home after your studies. So great. In this, you can do two things. We have done for some of our clients, we have done a business plan who wanted to start their business. For some of the clients who want to go back to their home country and they want to work, so provide a search base. We do the research and we provide information where salary levels in that country, what are the requirements for that job, and what is the starting salary, and everything will be included in this clear plan. Solid family, financial, social ties to home country. So in this, if you have a family in your home country, and then if you have financial situation is much better in your home country, like it's not that money in the account, it comes to the different factors, property and your job situation, and then social ties to your home country. If you are included in any of the social ties in your home country, that will be helpful. History of complying with visa conditions. So if you are in Australia or in any other country, have you complied with the visa conditions? And that will be very positive to your GS requirement. Limited to no income in Australia. So in this, one of the example I will give from my recent case, which we got remitted back to department by ART. The applicant was here in Australia and her visa was refused and she had no income. So in Australia, because she was dependent on her brother, her visa was refused and she was not allowed to work. So she maintained that condition. So that was helpful in her case. Again, this is not a checklist. A client can have both positive to work with and negative factors to work around in establishing GS criteria. For instance, if a client has circumstances that are usually perceived as unfavorable or detrimental to their GS assessment, such as having no assets in their home country, it is important to justify the absence of assets. So, for example, explain the client's youth, recent complete studies, or family's financial support. So if the person is not financially strong himself, he can provide the proof, evidence that his family is financially solid and they can support him during studies, and why they want to go back. So present alternative arguments, highlight the lack of assets in Australia to show no incentive to overstay. So if the person doesn't have any assets in Australia, like any properties, any relationship, that will be the best thing to do. That will be helpful him to satisfy this. Focus on overall narrative, emphasize the client's genuine intention to study and return, supported by strong family ties, career aspirations, future employment opportunities, social and cultural connections to their home country. As said before, they will consider what you are going to do after your course, so that need to be detailed. Importance of GS. To reiterate, for a client to be granted a student visa, they must demonstrate that they satisfy the genuine entry and stay requirements. Again, just remember that all the cases which were lodged before 23rd of March 2023, they are under Ministerial Direction 108, and the current one is Ministerial Direction 106. How Kris Ahn Lawyers can help? We provide a tailored GS strategy based on your background, strategic case preparation to mitigate refusal risk, expertise in handling reviews and appeals. And if you need any kind of help, just book a consultation with us. So let me recap the points. So genuine student requirement is for the student visa 500, which includes the applicant's circumstances in their home country, the applicant's potential circumstances in Australia, value of the course to the primary applicant's future, the immigration history, if the applicant is minor, the intentions of parent, legal guardian, or spouse of the applicant, and any other relevance which includes they satisfied course requirements, participated in assessments, completed their courses on time, so history of starting but not completing courses, all these relevant factors will be considered.